Welcome everyone. So today we'll be doing introductory class or introduction class of criminal law. So here if you will see if I believe that you all have gone through your syllabus, and in the syllabus as you have seen that there are 32 points. So 32, that is a big syllabus, even more than 30 pages I believe, or at least more than 20 pages. So that syllabus is there. But what I have done in my, or how I will go through understanding, making you understand this criminal law, there are I have bifurcated that syllabus into 10 steps. So those steps are what we have to understand. And the question will come from these steps only. So here, if we will see, first of all, we have to understand criminal law. That means what is the source of criminal law, to start with. Fine. Just in case of introduction class only, I'm explaining you this. Otherwise, we will be more focusing on the constitutional and interaction of constitution and criminal law. How we will be, how they two are interacting with each other, how they are actually dealing, or how we have to understand when a criminal law is being made, how we have to understand that how constitution plays an important role, like section 7 plays a very important role, section 11D plays a very important role in framing the criminal law. That when I'm saying framing, that means it has to be in line with section 7 or section 11D. Along with that, there are other sections as well, like section 10, section 11, section 12, so section 9. So section 12, if you will see, that is with regard to sentencing. So these all section 8, so these all sections of charter I am talking right now, section 7, 8, 9, 10, 11 and 12. So these all are in relation to charter. So these section plays a very important role in framing in framing a criminal law. Fine, these are so this is how we have to understand. So you will always find some or the other question from this particular aspect when we have to deal with criminal law and its constitutionality. That means the act which has been done by an of, let's say, police officer or a state authority. So that act is valid or not, that we have to analyze in case when the question comes as to arrest, when a person has been arrested, when question comes as to bail, when the bail is to be granted and how it has to be seen, or when the question comes to search and seizure, there we have to look into that. And when sentencing part is there, then of course we have to look in that regard. So this plays in that we have to understand how these sections plays an important role to make you understand, to make you apply criminal law as per charter. Fine, so that we will be understanding. So if we will look upon here, introductory of criminal law. So to understand criminal law, we have to go to the source of criminal law first. Fine. So what are the sources of criminal law, if you will see? So first and foremost, if you will see, constitution is the source. Particularly as we have seen that lawmaking power of a parliament is given in charter, we can say, Constitution Act 1867. So that is there. And as I have told you just now, that whenever a parliament makes a law, as the power is given to them to make law with regard to criminal law, it is federal law which is having exclusive jurisdiction, we can say, or we can say it is the federal subject under section 91 subsection 27, which gives criminal law head of power to law making power to federal. So that is there. Federal parliament can make law under the Constitution Act 1867, but they may make this law in line with the Constitution Act 1982. That means it should not. Section 52 plays a very important role, and with regard to when we have seen in other areas, like when we did our constitution law, when we did our administrative law, there section 52 plays a very important role, or specifically in constitution when we say why, because legislation when is being made, and there specifically we have read section 7, which deals in life, liberty and security. So all, if we will look upon, if we have to decide whether a law is criminal in nature or not, we have seen in division of power aspect that there should be penalty. Fine. So that is 3P should be there, and penalty should is one of the necessary requirement to declare that particular law is criminal in nature. Fine. So that will fall under the criminal head of power. So that we have seen there. So constitution plays a very important role in, or that is one of the very important source, we can say, source of criminal law. Then as I have told you that this section 7, and we have discussed section that we will be discussing in detail in our regular classes, that section 7, section 11D, section 12, section 8, section 9, section 10, right to counsel, when we talk of section 10, plays a very important role. So these all are there. Fine. So that means they are also the source of criminal law. Then if we will go further, then next source is statute. As I have told you, the power to make law, that means is with federal parliament or provincial legislature, as we have seen ancillary power doctrine is there, or those legislations cannot work in watertight compartment. But here we are majorly concerned with federal legislation. So if we will look upon here, so federal legislation or statute, we are talking here like criminal code. So that is one of the source of criminal law. Fine. And other legislations are also there, like drug related legislations and all. Then common law. Again, if you will see, common law is the third source, which is also again very important. Why? Because when we talk of defenses, then those definitions which are being given under common law, that applies. Like take an example, if we will talk of automatism, fine, mental disorder. Section 16 gives mental disorder defense, but when we say what is mental disorder, when we have to decide what is mental disorder, common law gives a definition that we have to look in whether it is a disease of the mind or not. It should be understood, or the definition given under common law precedent, or we can say under common law, that is the test that we have to determine whether there is a mental disease or not. Reoccurrence is one, that is we can see, and in detail we will be doing in defenses, when we will be doing defenses. So these are, if you will see, these are the steps to if you will understand or sources, there are different steps which are being given to us, so that we have to understand. Then going further, if we will as in my mind it comes steps. Fine. So how to answer the question? So first of all, we should understand that. So here, if we will see, in criminal law cases, there are a fact or the issue is being given to you, and you will determine the issue very easily, that what they are seeking, what they are asking from you. Let's say they will provide you with section. Sometimes they will provide you with particular terminology, that whether this has been like assault, whether there is an assault or not. So they will not provide you section, but they will use the word assault. Then you have to go to the respective section and then you have to explain that. Sometimes in defense question, they do not provide you with what defense is available. That means they will not say specifically whether duress is applicable, or they will not say specifically sometimes that whether self-defense is there or not. You have to pull out from the facts that defense is applicable or not. Fine. And then we have, our approach here is that to answer these questions, or when it comes to section, let's say take an example where whether any charter right under section 10 is infringed or not, if that is the question, or charter section 7 is infringed, or charter section 8 is infringed, or any charter right is infringed or not. So that if there is a direct question with regard to that, then of course we have to determine what part they are talking of. That we will be understanding in our regular classes, that I have IRACs made of all those rights in regard to which they will be asking. Fine. So IRACs are there, notes are there. So those notes will help you to answer the question. So that is there. So if we will go, as I was telling you, steps. So steps with regard to answering the question is, if you will see, so first of all, issue is to be determined. If we determine the issue, then there is respective rule. So that we have to write, like let's say some defense is there, or when it is an offense question, fine, a code section is given to you. Like take an example of assault. Assault is given in section 265. Fine, it defines in section 265.1 and 265.2. Fine, and there is in 1 there is A, B, C, and all those that we will be reading when we will be going. So that means we have to read the entire section first, and then we have to decide what are the ingredients of those sections, or that section particularly. So let's say, take an example, assault with regard to bodily harm is also mentioned in section 267, but definition of assault is given in section 265. So that means whenever we will be reading section 267, we have to also read section 267 along with section 265. So that means we cannot independently give an answer of section 267, that is assault or bodily harm, without actually triggering section 265. So that is how we have to understand, or in detail we will be going in our regular classes. So then the rule is to be mentioned here in offense question. The rule is AR, that is actus reus, MR, that is mens rea, or fault element we can say, and then causation. So these three things we have to see. So these rules we have to pull out, we have to make out from that particular section, and then the application part. So third step, that is application, that is very important. All the, as we have, if you will read Williams, it says all the elements of the crime must be mentioned at the same time. Fine. Then only one will be charged with that particular offense. So that we have to understand. That is the step number 3 that we have to write about application, and then conclusion, whether we have to that whether he will be charged or not. So in application there are different other things also that we have to also explain, like burden of proof. Who have burden of proof? So these in our first class we can say, or in our, when we will be doing when we will be doing charter and application of charter, or when we will be doing criminal law and constitution, at that point we will be understanding that initial burden is always on the crown, or we can say prosecutor. So they have to prove beyond reasonable doubt. Fine. So that is the burden they have to discharge. So that is there to prove, or to prove the guilt. Fine. To prove blameworthiness. Fine. So that we have to understand. Now going further, as I have told you that I have made 10 steps here, or particularly they are 9, but 10th we have appeal, so that is the 10th one. But particularly there are 9 steps in which the entire syllabus is divided, and these steps will explain you the syllabus in that regard. So first is, when we have to understand constitutionality, fine, that is the first step, that parliament makes a law. Fine, that will be provided to you, that parliament has made a law. This question generally will require your understanding of regulatory offenses. Fine, either parliament will create a law, new offense, you will be provided with a particular section that this is what parliament has made. It can be related to let's say government official, police code will be there, or some penitentiary will be there, or let's say, take an example, imprisonment code will be there, where warden of the imprison, or warden have to do in a such way, or some act has to be done by warden. So that is there. So something will be provided to you with regard to that. So in that sense we have to understand that Parliament has created an offense, and if that particular offense is being shown to us, or some provisions are being provided to us, then we are talking of regulatory offense. Fine. So, or sometimes they may say that Parliament has amended a particular law. This section has been amended. Fine. Then it can be a question of constitutionality. Then we have to check under the Constitution. Fine. Or sometimes it may say Parliament has made a new offense. Fine. Again, constitutionality is to be checked, and requirement of, if it is related to regulatory offense, then we will be writing with regard to that. Fine. So, or we will check regulatory offenses as well. Fine. So as we can see, regulatory offense, when we are talking, that means if it is related to any environment, safety, fine, license is required somewhere, where license is required, they are regulatory. They are regulating your conduct. So that's why, or it is also called public benefit offense. Fine. So for the benefit of the public, they are regulating your conduct. So advertisement, let's say, fine, health and safety sometimes. Sometimes they may also give question with regard to that, like vaccination, COVID vaccination. Fine. They may say that it is mandatory made by the government. They said that it is mandatory. Otherwise, you will be punished. Let's say they may give you, let's say, 1 week punishment or whatever. Fine. So they may give. So this is a particular legislation or that particular regulation is made, and you have to decide now whether it is absolute liability offense, whether it is strict liability offense, or mens rea offense. So between these three, we have to decide. Fine. Then there are certain in certain cases there are provisions which, if you will see, are given with regard to corporations. So corporate crimes, they are also in the same IRAC. Corporate crimes and regulatory offense are in the same IRAC or notes. So if the issue is related to corporate crime, then we have to deal accordingly. Fine. Whether the corporate have vicarious liability or not, that we have to understand. Fine. Or what is the directing mind test? So will of the company, that is what we have to understand. Fine. Senior officer concept, that is given in section 2. So that we have to understand with relation to corporation. So this is in relation to regulatory offense, we can say. Fine. So here what will be given to you, that most of the offenses under regulatory, it will be told to you that it is enacted by parliament, or it is enacted by province, or it is enacted by municipality. Fine. But generally, as I have told you in the beginning, that it is parliament that we are more concerned with. Parliament will make the law, but this is not much important. The end line is that we have to understand it is a regulatory offense. Fine. So that is there. So the purpose of that regulatory offense, if you will see, to deter the behavior of that person, or if there is a risky behavior, or let's say a person, take an example of road driving, driver is driving on the road. In that case, if they have made a particular amendment to, or they have made a regulation, then it is a regulatory offense. Fine. To prevent harm of being it happening. So that means any harm which may happen. So it is for the prevention of that particular harm. Fine. So that is what we have to see in regulatory offense. Then we will see that although we will not have to prove what is the purpose, what is the thing, but we have to determine whether it is a regulatory offense or it is not a regulatory offense. That aspect we have to understand. Then if we will go further, like if you will see sections, constitutionality, as I have told you that in this particular step we will also understand about constitutionality. So that constitutionality, as we have seen, we will see that it is to be checked whether when the law is made, whether that law is valid. So very important section is section 7, to check the validity of the law, to check the whether the law is justifiable, or justified. Fine. So we have to check by principle of fundamental justice. Fine. So here in section 7, if you will see, there are 3 things that are being triggered. Like if it is required under section 7 that morally innocent person should not be punished, then further it requires that morally involuntary act should not be punished. Fine. Or involuntary act should not be punished. And third, procedural fairness, that we can see from section 7, and that we can pull out from section 7. So, and if we will look upon section 11D, it says that, and it is a very important section with regard to criminal law. Why? Because there is a presumption of innocence, that it is presumed that the accused is innocent. So this presumption of innocence plays a very important role in criminal law. That's why when we read above, when I was explaining you that the burden of proof we have to prove, we were discussing the question part, how we have to answer the question, there we have seen that burden of proof is on prosecutor or the crown. Why? Because this presumption is there, that accused is presumed to be innocent till proven guilty. So that plays a very important role. And second aspect of or Second requirement of section 11D, if you will see, which comes out from section 11, is that the decision should be given from an impartial decision maker. Fine. So impartial court should be there. Again, procedural fairness should be seen here. So that is also there. Now coming to second step. So coming to how I will take the classes, my classes are interactive one. Fine. So, and that I used to do an interactive classes. So that I used to ask whether it is clear to you or not, and I share sometimes if time is less or if other things are not going smoother, then we can go through recordings as well. Fine. So recordings will be shared to you, and accordingly we can have at weekends we can have the classes, and that is how we can go further. So there are my notes, if you will see, they are 80 to 90 pages notes, and these section 7, 11, how we have to deal with them, section 12 with respect to sentencing, fine. So these all sections are section 10, if you will see, that is with respect to right to counsel. So these all sections we will be dealing with them. Okay. So those are my notes, if you will see, they are there. So we will be dealing with, like section 11 talks of judges or trial judges, how judges and jury aspect, that we will be dealing with. So we will be dealing, don't worry about that. Fine. So going further, second step now. What will be the second question on? So this will be the first way of asking the question. They may ask you with regard to section 7 or 11D. So whether the charter is valid or whether the act which is being regulatory offense or any act which is passed or amendment which is done given by the parliament, fine, or which is made by the parliament, that particular law is valid or not, that is what we have to decide. Fine. So based on section 7 we can say, but here if you will see, we have already read a test which is given in Bedford Carter, where we have seen that, and we have done that principle of fundamental justice test. Fine. So here in the criminal law we will also read about Deviault principle, fine, which were given in Deviault case. Fine. So that principles we will also understand in this particular chapter, fine, or this particular IRAC. That means how we have to go with the constitutional aspect of when section 7 is being dealt with. Fine. So that we will be reading Deviault principles along with fundamental principles of fundamental justice, principle of fundamental justice under section 7, that we have read in our constitution law exam, if you have given that. If not, then we will understand in our regular classes about that and Deviault principles as well. Fine. So those Bedford Carter and Deviault, both principles, they are the validity of the law is to be seen, or we can say whether the law will stand or will not stand, will be justified under principle of fundamental justice, will be seen based on these two principles. Then going further, second point, that is police enforcement, second step. Fine. Now we are talking of enforcement of the police. Fine. Enforcement done by the police. Let's say some violation has been done. Fine. Some act has been breached. Let's say assault has been done. Now what we have to do, arrest is to be done by the police officer. So there are certain requirements when our arrest can be made. There are requirements how the arrest can be made. So that we will be understanding. So that is given, if you will see, in section 9. So section 9 of the charter, remember. So the police or the enforcement officer have acted as per the requirement of section 9. That is what we have to check. Fine. We have to also check section 10. Fine. So section 9, section 10, that whether right to counsel has been given, specifically section 10B, if you will see, that is with regard to right to counsel. So section 10, that whether they have followed, that they have told the person who is being arrested that for what reason they are being arrested. Fine. And to inform, let's say they have asked something from that person who has been arrested. So they have whether informed that you have a right not to speak anything right now. Fine. So those things that we will be seeing from the fact that police officer has done this or not. So, or enforcement officer has done this or not. So here we are talking of police enforcement. This step is focusing on police enforcement. So this here we will be dealing with arrest and detention. IRECs are there, how the arrest should be made, what are the requirements, and how the rules are being given, and then accordingly application is to be done. Whatever rule is breached, that is we will mention, and then we will complete our answer as per I have told you rule application. Fine. So that is accordingly. Section 9 is in question, arrest and detention with regard to that, section 9 of charter. And when we go further, like search and seizure, within this police enforcement also comes search and seizure, section 8. Here section 8 of the charter is triggered. So when we talk of search is done or not, seizure, search or seizing certain evidences or certain documents, so that is there, evidence of course. So whether that is as per law or not, as per charter or not. Fine. So that is, we will be reasonable expectation of privacy, that we will be understanding, that concept we will be understanding. We will be understanding search incident of or arrest. If arrest is done, then it is a search incidents. Fine. So that is, we will be understanding that aspect. Then right to counsel, as we have seen, or section 10, we will see that aspect as well. Fine. So here in this particular police enforcement, these all rights are there. Specifically, if you will see, the remedy is provided in section 24, because this is an individual right infringement of that police officer. While exercising his power, he has infringed the right of that particular individual who has been arrested, or search and seizure is done, whatever. So in that case, in search and seizure specifically, when an evidence has been collected, then it is subject to admissibility, subject to section 24. We will be looking into that, whether it is admissible or not. We will be understanding, although that is not that the question may be asked. Fine, but still we should understand that. Then going further, third step or third question now we are talking of, and this is very important question. Fine. So that from second step, as I have told you, from that step you will find one question that will be of 10 to 15 marks. It may be on arrest, it may be on detention, it may be on search, it may be on seizure, it may be on right to counsel. So that 10 to 15 marks question will be there. Fine. Same will be with the regulatory offense, as we have seen above, or constitutionality is asked sometime. So that is step number 1. Step number 1, step number 2, now step number 3. For sure there will be question of at least 20 marks. Fine, or more than that even. So this is prosecutorial charge. Fine, where we have to decide whether this particular person who has committed this particular act, fine, he has done, facts will be given that John has done this thing, or Mary has done this thing. So that will, the facts, XYZ person has done this thing, that he was doing this, and that facts will be given to you. Fine. He has pushed someone. So assault is there or not. He has pushed, he has hit someone with a punch or whatever. So force is used. So here, if we will see, we will be more particular about the part which I was telling you when we were doing offense question. So this is an offense question where an offense is given. Fine, like assault is given to you. Fine, that this person John was going in one particular mall, and there he found that some person has they found that two things, one particular doll was there, he wanted to buy it for his daughter or his son, and that particular doll, and the other person snatched that doll from him, so he hit that person's, whatever happened, or he reached there first and he picked that doll, and that was only one piece, and then they have a fight or whatever. So they may say any scenario will be there, that assault is there or not. Fine. So when he punched that person, intentionally he punched, fine, these facts will be given to you. Accordingly we will give an answer. Fine. So assault, if we will read section 265, there it says that if anyone uses force without the consent of the other person, with an intention to give bodily harm. Fine. Now these words are very important. So one, if you will see, while reading this line, there are four things that we have to see here. So first they have said that use of force. Whether force was used, we have to explain that he punched, that is use of force. Fine. Then this is actus reus. Fine. So this we have to understand, that actus reus, mens rea and causation. Fine. Accordingly we have to explain. So actus reus we have to divide. From reading this particular section we have to divide. That the rule we have to write, that this is actus reus, this is mens rea and this is causation. These things we have to prove. Fine. To inculpate John in that particular assault, that two or Crown will be able to prove beyond reasonable doubt that these all elements are present or not. Fine. So here if you will see elements, what elements are there? Actus reus, that he used the force without the consent, that is actus reus, and then intention, that is mens rea. Fine. And then whether he has caused this particular, that means he was the sufficient cause. He was the sufficient cause for the harm that has been inflicted to the other person. So harm also we have to explain, that harm as is given in section 2. So that also we have to explain. So the definition of harm, or sometimes weapon is used, then the definition of weapon is given in section 2. And we have to explain that weapon was, this will be considered another definition. Let's say a stick was used to beat. Fine. So it will be a weapon. So that we will be accordingly mentioning. That means however, how the things are given in the particular section, we have to answer accordingly. Fine. And that the fact will be matching with that. So we have to go with it. So this is how we have to understand. So actus reus, if we will understand, what is actus reus? It is prohibited act. So it is not act. So there are two words here, actus plus reus. So prohibited act, prohibited plus act. So understand that it is not just act. It is act which is prohibited, which is forbidden by the law, which is forbidden by that particular section. Fine. Such act which is forbidden. So here such act is, in case of assault, force without consent. So such act which causes the bodily harm. Fine. Force, using of force without consent, which causes prohibited act. So that is causing bodily harm. So that is what we have to look upon. Consequence which is forbidden by law. Actus reus means that consequence which is forbidden by law. So in totality we have to understand actus reus. It is not just an act. Fine. So act along with which is prohibited, without consent. Force without consent. Force can be with consent even. So then it is not an actus reus. So let's say some friend pushed the other friend just in mall, that with consent, let's say. So that is no, still here is a push. Let's say when let's say a trivial, let's say they agreed to fight. Fine. And there was a minimal force used, by they were punching each other, not that much strongly, but they were just joking that okay, and they were touching each other and they were punching each other. Fine. And did not harmed anyone. Fine. Or they used the force. They used force when they punched, however slightly it was, but they used the force to push that particular person. So that is because the consent was there, that punch will not count as actus reus now. Fine. So prohibited act, that we have to understand. So it is prohibited act, act which is forbidden by law. Same is with mens rea. Mens rea is something which is inside the mind of that particular person. It is guilty mind. Or we can say again mens rea. So rea is again the consequence of which is forbidden by law. Fine. So mens rea. So such intention, the consequence of which is forbidden by law. Such intention should not be there. So such intention of whom consequence is forbidden. So that is fault element. It can be divided into we can say 5 types as is mentioned in the criminal code. Like let's say they have mentioned in different sections you will find different type of mens rea that is to be proved by the crown beyond reasonable doubt. So that is, if we will understand in this fashion, that is intention, that is at the top. A degree less than intention is knowledge, and degree less than knowledge is willful blindness. A degree less than willful blindness is recklessness, and then it is a degree less than, we can say, or in certain offenses we can say that there is a requirement of negligence. Fine. So we will be understanding that in detail in our regular classes. Fine. Mens rea, I have an IRAC, we can, and different IRACs and notes are there with regard to mens rea, actus reus and causation. So we have to pick and choose from those notes that what is applicable in this particular case. If the section demand it is intention, then we have to go within intention, and then we have to explain accordingly that this intention is present from the act, from the facts which are being given to us. Fine. So remember that mens rea is always, if we will see, we have to see intention. How we can determine intention? Fine. Can you tell me how we can determine an intention? To understand how we will determine intention, that this person has that intention or not, from the conduct. So conduct tells us that he had that intention or not. Always remember this. So conduct plays a very important role. Why? Let's say a person wanted to kill other. Fine. How we will determine that this killing was the intention? In one scenario, he shot that person straight on head. Fine. In another scenario, he shot that person on foot. In here, he has conducted in two different ways. One straight on head and another on feet, on that particular or leg of that person. In which situation it is, he has made certain that he should die. When he shoots at head, at that time it is, his intention is very clear that he wants to kill that person. That is how intention is being seen now, conduct. Now he shoots at feet. His intention is not to kill that person, because there are chances that he can go to hospital and he can be, we can say, he can given a medical medicines and all, and he can be good enough, he can live. So his intention is not to kill now. Okay. So this is how we have to understand. This is how we have to understand that. When we understand in this way, that we can also use this terminology that overt is the key to covert. Covert is something that is inside the mind, and overt is something which is outside. That means the conduct, how he did that. Fine. Intention, when intention we have to see how he did that. Fine. So this is how we have to understand. We will go through it in detail. What is knowledge, how we have to determine knowledge, and all those things, willful blindness. Fine. So eventually we will be going there in our regular classes. Fine. And that is fault element, and these we will be understanding from the facts, that whether these are present or not. Then going further, fourth step. Again, a question will be from this step. This is defense. Fine. Fourth step is now in the above step, that is step number 3. You were a prosecutor. You were given a role of prosecutor. You were given a role of crown prosecutor. That now you have to tell whether you can prove or crown prosecutor can prove in that above question, whether crown prosecutor can prove that this particular act, if we will see, or this particular act will fall under the definition of, or will be charged, or that particular person will be blameworthy or not. Fine. So this we have to prove in the above step. Now then, I have not discussed about causation. Fine. We will be discussing in regular classes about causation. Fine. Although I have discussed the important aspect of it earlier. But so if we will look upon here, only one line or two I have said. So we will be discussing in our regular classes. No. Then going further, defense. Now here you are a defense lawyer, criminal defense lawyer. Now you have to think with regard to defense lawyer, that how we can go for defense, whether we can give defense in this case or not. Remember that it is not mandatory that we should give the defense. Fine. But if it is available, then only we can defend. This is not that we have to give the defense, but we have to determine that this defense is there. Whether the act fall within this defense or not, this we have to determine. So there are different, as I have told you above, when we were doing source of criminal law, there I have explained you that common law is plays a very important role with respect to defense. Fine. So those are also there. So common law plays a very important role. Fine. And if we will see, there is section 7 also gives an idea with regard to why we should not incriminate a person, or why we should not why we should give the defenses, like if it is involuntary act. So involuntary is very important thing. From there we can see there are different defenses which are coming out of that. But although not only this point is important, there are many other ingredients as well, or we can say elements in different defenses that we have to see. Like involuntary act may be shown by self-defense, it may be shown by duress. Fine. So that involuntariness is what we will check. Fine. Sometimes that is or sometimes it is morally innocent person. Fine. So that aspect. So these will be considered, and there are different defenses. Fine. So there are common law defenses, there are statutory defenses. Statutory defenses, as I have told you, that there is automatism, and there is section 16 as well, disease of mental disorder. Fine. Defense for mental disorder. Fine. So that is, we will be understanding in detail. Fine. With regard to defense counsel, we have to understand these things. Fine. Then here also, if we will see this 11Ds play a very important role. Presumption of innocence is there. So that is very important here. And then we can also look in here for like defense lawyer has a role in relation to plea guilty. So that also we will understand that plea guilty is to be asked or not. Fine. So here, if you will see here in this circumstance, in this plea guilty, I was telling you that plea guilty, sometimes it is a question may come with respect to plea guilty of 5 marks with respect to PR, we can say professional responsibility. Those aspects can also be discussed here. And then defenses, importantly here, for sure you will find a question on defense. Fine. So defense is when a person commits a crime, or commits an act which is otherwise a crime because of the threat, we can say, when he is under duress, or because of the dire circumstances, because of the necessity, we can say. Fine. Or other let's say self-defense, we can say, or other that is but he did not mean to harm someone. Fine. But he did not have realistic choice. Fine. But to commit the crime, he does not have any choice, but he have to commit the crime. He has to save himself. Self defense, if you will see, take an example of that. So these are there. And here, if you will see, sometimes like when we see mental disorder, fine, or when we see automatism, the onus is on the accused here. Fine. He has to discharge that onus. He has to prove that this defense applies. So these defenses, we have to see the onus on the defenses are on the accused. So that we have to understand, that we have to look in with regard to this. So going further, next step, if you will see, is that clear? Till here it is clear. So going further, fifth step, if you will see. So fifth step is pre-trial. So pre-trial detentions are there, or detention is pre-trial detention, we can say, that is right to counsel, section 10B. We have already dealt in police enforcement, but here also we can also understand with regard to pre-trial detention that right to counsel was given or not, section 10B. And most importantly in this step is bail. So there may be a question. It is not for sure that the question will be there, but there may be a question from this fifth step. That is bail. Now, what we will be reading further, there may be question on that, or there may not be question on that. But till now, these 4 steps, if you will see, there will be for sure one question or the other from these steps. But there may be question from this pre-trial detention, right of pre-trial detention. Again, section 10 of the charter is triggered. Bail, whether the bail will be granted or not, that is under section 11E of the charter, which is what we have to understand with regard to bail. Fine, which says bail must be granted. The general rule is bail, not jail. Fine. So general rule is that we have to go to, we have to grant, or one should get bail as a right. Fine. That is, he should get bail. Fine. But there are certain circumstances which we will be reading in our regular classes, that when the reverse onus clause is there, or when the onus is on crown, when they can seek for the conditions which are more severe conditions, we can say. Fine. So ladder approach we will be understanding here, that what is the ladder approach with regard to jail. Fine. So there is this section, there are exception to this section 11E, as I have told you, reverse onus clause is there, that the onus is on now the onus will shift to the accused if he has breached some conditions which are given in section 115 6 that we will be reading in detail in our regular classes. So that is when we will be understanding bail. 115 is very important section with regard to bail, so that we will be understanding. Fine. So in this particular area, there might be chances that the question might come, and this is 10 to 15 marks question if it will come. So then going further, next step. Now next step is preliminary inquiry. So this is what we can also ask with sometimes. Fine, not for sure that it will always be asked, but sometimes it will be asked, it might be asked. I have an IRAC with preliminary inquiry, so it can be used. Fine. So that is, first of all, we have to understand it may ask with regard to classification of offenses. They may ask in here an IRAC with notes with regard to classification of offenses. We have to understand, like it is whether it is a hybrid offense, whether it is summon offense or summary offense, or we can summary offense, or it is cognizable offense, or it is indictable offense if you will see. So summary offense or indictable offense, so that we have to understand. And there is hybrid offense. So summary offenses are which is 1 day less than 2 years. If that is their punishment of that offense is that is called summary offense. The procedure is different, that we will be understanding. And then there is indictable offenses. So these indictable offenses, if you'll see, they are again more than 2 years, that is there, but the procedure is different. It has to be initiated by indictment, so that is there, that we will be understanding. Then there are hybrid offenses, where the prosecutor have discretion whether to go with indictment or go with summary. Fine. So summary procedure, as we see that it is small, procedure is speedy. So that is why whether we can go with speedy procedures, that is summary. If it is less than 2 years, 1 day less than 2 years, fine, then it is summary or indictable offense. This classification we will understand. Fine. So as to mode of trial, we have to understand. Fine. Then there are different other issues in these steps. Preliminary inquiry, I was telling that more serious cases requires preliminary inquiry. That we will be understanding how the preliminary inquiry and what are the powers of preliminary inquiry judge, and what is seen by the preliminary inquiry, whether to go further for the trial or not. This has to be decided by preliminary inquiry judge, looking into what evidences do prosecutor have and what evidences do defense lawyer have or defense have, fine, accused have. So weighing that those evidences, whether it is fit to go for a trial or not. So this is preliminary inquiry, that initial inquiry which is being done by the court, whether we should proceed, that whether prosecutor has sufficient evidence to prove the guilt of the accused beyond reasonable doubt. So that is what preliminary inquiry is for. So it is for more serious offenses. In detail we will be going in our regular classes. Then if we will go further, it is disclosure and production. So this sometimes also a question may be asked with regard to disclosure and production. So disclosure, if you will see, it is the duty, again PR question can be there along with disclosure, that it is a duty to full answer and defense of that means the whatever are the fruits of investigation, we can understand in this fashion, or whatever is the outcome of the investigation by the crown has to be disclosed by the crown to the defense. Why? Because he has to give defense, he has to be right of defense, he has to be given full information, fine, that on what evidences crown is relying, so that he can go with full answering that particular we can say answering that particular evidences, or answering those particular charges. So that is there, or evidences, they can make a full answer and defense, that is a right. Then when we say production, now production is when the documents are in the hands of third party, then we go to the court and ask for production, fine. Then this we can read O'Connor application is there, that we will be understanding, and accordingly we will be doing it. So production aspect, then when it is the documents are in the hands of third party, so how we have to proceed with that, to discovery and disclosure and production, that aspect we will be understanding. Then going further, seventh step. Now this step is question may be asked, but it is jury selection. Jury selection for more serious crimes only or cases only, jury is there. So jury selection, if we will see, fine, how we have to do that, fine. Earlier there was predicate or we can say there was some Coco Penance case is there, which is very important with regard to understanding jury selection, fine. So Coco Penance has said that as a jury challenge to the jury, how it can be done, what is the procedure to appoint jury, fine. So that we will be understanding, and we will be understanding how the selection of the jury is to be done. So that aspect we will be understanding, that how jury is selected, fine. So IRAC is there, notes are there, we will be understanding that. Then in case of jury selection, if you will see, so that is earlier there was peremptory challenges, fine, but now they are not there, so that we will be understanding. Then going further, next step, if you will see, so next step is trial judge, fine. So that is again the pre-trial motions are there, that we will be understanding, that there are certain pre-trial motion for ascertaining the things, fine, like we can say whether the accused is if you will understand in this fashion, whether the accused is fit to stand trial or not, that aspect pre-trial motion is there for with regard to that. So we will be understanding. There are many others pre-trial motions, I have again notes are there, IRACs are there. Accordingly, if the question is asked, generally there are not much chances that the question can be asked from this step, fine. So step number 8, but they may ask. Charter section 11 is involved in this. Whenever we talk of trial judge, section 11 says there should be impartial decision maker, fine. So or independent court should be there, so that is what we require. So trial judge is there, pre-trial motions are there here. And another thing that is very important with regard to this is trial to be completed within reasonable time, fine. So trial within reasonable time, then that we will be understanding. Jobidon case is there, fine. So that we will be understanding here, fine. So that is Jordan case, not Jobidon case. Jobidon is for an interpretation, fine, it is Jordan. So Jordan case is there, so that we will be understanding. So going further to the 9th step, and now this is an important step. There are let's say 80 to more than 80% chances that the question might come on this. So this is sentencing. Now sentencing is after the trial is completed. Now sentencing is decided, how much sentence is to be given, fine. Section 12 is triggered here. Section 718 of criminal code is important, Fine. With regard to sentencing, we have to understand what are the principles based on which sentencing should be given. There we have to understand mitigating factors and aggravating factors based on which the sentencing judge will decide what will be the quantum of sentence. So that is there. And then other principles like denunciation or reparation. So these all principles will also be seen, though we will be doing that or everything in our regular classes. And there is again an IRAC for with relation to sentencing. We can see there are different principles, like with regard to aboriginals we have Gladio principles that we have to understand that in case of aboriginal, sentencing judge has to take a lenient view. So lenient punishments is what they can take, but of course that is not subject to, if there is mandatory minimum sentence, then accordingly he has to act. So that we will be understanding in detail with regard to sentencing in our regular classes. Fine. So generally, if you will see, there are community sanctions also that can be given by the judge. So apart from that, mandatory minimum sentences are there. Sometimes they are also challenged as they violate charter. Fine. And they cannot be justified under section 1 of the charter. So then, like there are examples that we will be doing, like in firearm cases. Fine. So that we will be doing. Then the 10th is, if you will see, appellate court. So that is the last topic, how to appeal and all. So that we will be doing in our regular classes. Generally not much is asked from there, but you never know, it may be asked sometime. So my notes are there, so accordingly we will be understanding in detail in our regular classes that how we have to proceed. Fine. How we have to go. So to sum up everything in brief, if you will see, we have started from source of criminal law. So we have seen that there are three sources, majorly three sources, that is constitution, statute, that is criminal code, and then common law. For defenses we will be reading common law, and that is important. And then there is now emerging sources, international law also. Sometimes that can also be considered as a source. Then there are different steps on which we have divided the entire syllabus. So first step is where parliament creates a law. It may be given with regard to constitutional challenges, that whether it will be we have to check the constitutionality of that particular section under section 7 and 11, or we may be asked with regard to regulatory offense. Then there again we have to check regulatory offense, whether it is valid under section 7, strict liability offense, absolute liability offense. With regard to that we have to understand mens rea offense. Fine. So absolute liability offense, requirement of absolute liability offense, when we can say there this will be not an absolute liability offense, or if it is an absolute liability offense, then it will not pass the fundamental justice test of section 7 and it violates the section 7, then we can say that. Then police enforcement we have seen here, that is the second step. We have seen search and seizure, arrest. With regard to that, when the police is enforcing their power, or when they are arresting or detaining a person, then we have to understand this section 9 of the charter, section 8 of the charter with regard to search and seizure. So arrest we will understand, not only physical arrest is arrest, it is psychological as well. We will be understanding that part. Then prosecutorial charge decision. That is again the very important step where we have to understand mens rea, actus reus and causation. Then if we will see defense, then next step is defense, where we have to go with different defenses which are there. And we have to understand about those defenses, like intoxication is one, like duress is another, defense against property is there, self-defense is there, and there are entrapment defense is there, color of right defense is there, officially induced error is there. So these all defenses and many more we will be doing in defense section when we'll be doing that. Then pre-trial detention and bail, that is there. So where we will be talking of pre-trial detention, as we will see, right to counsel and all, and we will be talking of bail, whether will be granted or not, and the onus who had to be seen. Section 11E is important with regard to bail, which says that bail as a matter of right can be given. So that is important. Then going further, preliminary inquiry, this is next step, and here we will be doing with regard to disclosure. We will be looking into classifications of offense, indictable offense, summary offense, hybrid offenses, and then production. Disclosure and production, sorry, so they are together, and offenses, classification of offenses are together. Fine, so that is there, and preliminary inquiry in more serious cases. Then next is jury selection. Fine, those we will be understanding. How to select a jury. Sometimes that question may be asked for 5 to 10 marks. It can be there. Then coco penance case we will be doing. Then next is trial judge. Again, section 11 is triggered here of the charter, and pre-trial motion and trial within reasonable time are the issues which we will be dealing in this. And then sentencing. So sentencing is important with regard to a question if is asked, because this is a very too we have to deal with many concepts while dealing with sentencing question. Fine, so those things we have to keep in mind. So we will be doing that in our regular classes. Section 108 718 is the of the criminal code is very important section with regard to sentencing. Fine, so we will be doing that in our regular classes. I hope you could have gone through the entire syllabus now by this, and in between we have also seen that there are issues with relation to PR. So that is also there when we talk of defense counsel, plea guilty, or when we talk of disclosure. With regard to that, PR will be there. Sometimes conflict of interest and confidentiality, that is also being asked of 5 marks or so. So we have to understand that even. Okay, I believe this will be much clear to it would have cleared your understanding with regard to the approach towards criminal law. Thank you.